Thank you so much, Mike. Welcome to today's program entitled Spotlighting California, Colorado, New Jersey, New York, and Oregon Paid Family Leave Development. This session is part of Seyfarth Shaw's Guidance on State and Local Paid Family Leave Laws webinar series. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. And at this time, I would like to turn it over to Tracy Billows. Tracy, please go ahead.
Thank you, Kelly. I really appreciate it. And a big applause from all of us to Kelly. She helps get all of this organized for us, gets all of our materials together, and makes us all look good. So thank you, Kelly, for all of your great work. We've been keeping Kelly very busy. This is part 2 of our webinar series on guidance on state and local paid family leave laws. Previously, we covered Massachusetts, Connecticut, Washington, D.C., and Washington State. And today I'm thrilled to be joined by some of my favorite team members, because we do work together as a team on all of these different paid family leave issues. I have with me today Marlon from New York, who is going to be talking to us about some New York and New Jersey updates and things that are happening there. Chelsea from California, you can see the beautiful sunshine there, right? Because California has the sunshine. Chelsea's going to be giving us an update on California. We have Josh, who is going to be giving us an overview and preview and doing what he does best, which is looking into that crystal ball of his and giving us predictions as to what we can expect, given what we've already seen. So I'm always thrilled to see that. And last but certainly not least, we have Meg, who will be sharing with us updates on paid family leave from Colorado and Oregon. She did ask if she could attend from those locations, but we said no, she had to be with all of us for this webinar. So I'm thrilled to have all of you with us today. Thank you. If you go to the next slide, you will see that we have a pretty jam-packed agenda, but we are going to get through it, I promise. I'm going to start with a quick federal paid family leave update, and then Josh is going to take over from there on the national paid family leave overview, and then you can see the specific state updates we talked about. So next slide, Kelly, we can actually go to slide 6. Yes. So everyone has been asking us, what is going on with paid leave on the Hill, right? That seems to be the question of the hour. As you know, there was the Families First Coronavirus Response Act that had both paid sick leave components and extended paid FMLA components. That leave law did sunset December 31st. Interestingly, you know, we expected that law would get extended, but we'll talk in a moment about sort of where we stand there. Do know that to the extent that you are an employer who is covered by the FFCRA and are currently voluntarily extending the FFCRA benefits, both the paid sick leave and the paid family leave, you can still get those tax credits through March 31st, 2021, and you may even be able to get tax credits even longer than that, which we'll be talking about in just a few moments. Next slide, Kelly. So we had been thinking for quite some time, given what we were hearing from the Biden administration coming in and all of the efforts, that we were going to see either a reenactment of the FFCRA, an extension. As many of you know, what the Biden administration had said was that it wanted to expand it as well. So it wanted to expand the law to cover all employers, not just those under 500 employees. We expected some expanded time off, perhaps time off on top of what had already been provided. These were all of the things that we were expecting. However, the American Rescue Plan Act of 2021 does not have any of these components in it. which was a bit surprising, but given what's happening on the Hill in terms of trying to get a relief plan through, certainly we've seen lots of debate and back and forth. Where do we currently stand? Well, as I said, the FFCRA would not be reinstated. However, employers would get the tax credit, so those employers who are under 500 employees, if they continue to provide the benefits under the FFCRA through September 30th, 2021. So let's talk a little bit, next slide please, Kelly, about what is on the horizon. So what acts or bills are pending and what are we seeing coming out? Well, the big one is the Family Act, and this is the Family and Medical Insurance Leave Act. Many of you, as you know, have been dealing with similar acts at state levels, right? So this is very much akin to the state paid family leave laws and insurance programs that many of you are working through. It would allow up to 12 weeks of paid leave, and certainly would really change the landscape for purposes of you know, how FMLA is administered, because at the end of the day, you know, as you all know, you've been dealing with the unpaid FMLA and state equivalents for years and years, but now this would be this separate paid leave and insurance program to deal with. There's also a couple of other acts that have been pending out there, the New Parents Act and the Advancing Support for Working Families Act. I will tell you the one act that is really getting, though, the biggest conversation is the Family Act. A number of different groups that lobby Congress are really, really trying to find a way to see if they can make the Family Act work. So do pay attention to what's happening on the Hill. We may or may not be seeing paid family leave in our near future. With that, I'm going to turn this over to Josh, who's going to give you an update as to what we've been seeing. And take it away, Josh.
Thank you so much, Tracy. Hi, everyone. Good morning, good afternoon. Thank you so much for joining us for today's part 2 of our Paid Family Leave webinar series. As you'll see on the next slide, the nationwide landscape of paid family leave laws has a total of 11 laws that are currently in existence, either laws that are making paid family leave benefits available to eligible employees currently or that are scheduled to do so over the next few years. At the federal level, as Tracy mentioned, the FFCRA has expired, so nothing going on from a coronavirus perspective, and still in the early stages from a perspective of a more general paid family leave law at the federal level, so waiting and seeing there. At the state level, we have 9 states plus Washington, D.C. that currently have paid family leave programs. Those include California, New Jersey, Rhode Island, New York, Washington State, Washington, D.C., Massachusetts, Connecticut, Oregon, and Colorado. And then also one municipality in San Francisco with a paid parental leave ordinance that Chelsea will spend a couple of minutes on in a little bit. The laws that we'll be focusing on, as Tracy mentioned, are highlighted and bolded in that bullet point for you. Our first segment of the Paid Family Leave webinar series, we focused on what was happening in Massachusetts, Connecticut, Washington, D.C., and Washington State. And now we'll be focusing today on some other very important laws, particularly some of the new things going on in Colorado and Oregon for you all to be aware of. And Meg will be taking over on those points in just a couple of minutes. 1 or 2 things to be aware of with these laws. Number one, the 4 laws that are listed sort of from left to right, so California, New Jersey, Rhode Island, New York, are paid family leave laws, but they don't have a medical leave component. They don't provide paid leave or wage replacement benefits for employees' own serious health condition. It's only for employees who are absent caring for someone else, a family member with a serious health condition, bonding with a new child, and so forth. However, those 4 states do have statutory disability insurance benefit programs that are interrelated with their paid family leave setups. By comparison, from Washington State through Colorado, those locations all have a single program, a paid family medical leave program, that provides covered absences for both family and medical needs. So that's one way to think about the landscape as it exists today. Also, just as a heads up, so Massachusetts, which we spoke about again during our first series, the first part of this series, those benefits became available to eligible workers at the start of this year, minus employees who are actually caring for a family member with a serious health condition. Those will kick in on July 1st. And Connecticut, the payroll deductions to help fund that program started at the beginning of this year, with covered employers first reporting and remitting deadlines coming up in just a few weeks. So be aware of those as well. Next slide, please. So we've been doing this for our last few webinars and have found it to be really helpful for those in attendance. For those folks, who have operations in one or two or multiple of these states, it can help us tailor the next few minutes of our presentation accordingly. So no right or wrong answers here, but just take a look. You can see in which of the following locations, California, Colorado, New Jersey, New York, Oregon, does your company have employees? California only, Colorado only, New York or New Jersey, Oregon only. Number 5 is at least 3 of those 5 states. And then number 6 is at least 4 of those 5 that we'll be focusing on today. And you should be seeing the results popping up on the right side of your webinar screen momentarily. And again, we'll be using this information for, to help sort of tailor how we're going to proceed going forward. So give it just another second. Looks like the poll is just about ending. And as we wait for our results to come up, great, there we go. So we can see the overwhelming majority of folks have operations in at least 4 of these 5 states. So either all 5 of them or at least 4 of them, and then coming in second, folks that have operations in at least 3 of the states, which is fantastic and will really be helpful for us going forward. Thanks to everyone who participated in that. So now, without further ado, we're going to jump right into the state specifics here. I'm going to turn it over to Meg to get us started with Colorado.
Meg, I think you might be on mute.
Oh, there you go. You would think that I've gotten used to that after being remote for a year. Anyhow, thank you so much, Josh. Starting off the state-specific section here with Colorado. If you'll move on to the next slide for me, please. Thank you. So the important dates for the new Colorado law. In addition to the host of other fun laws that are popping up, Colorado passed Proposition 118 back in November of 2020, which creates the state-run paid family and medical leave insurance benefit for Colorado employees. And while this law was passed in late 2020, the premium withholdings don't begin until January 1st of 2023, and then employees won't actually be eligible to receive any of the benefits until January 1st of 2024. So there's quite a bit of time before the law has a real impact on Colorado employers and employees, and we do expect there will be a lot more guidance and rules issued between now and then. But the law itself provides a lot of useful information, so we are going to talk about sort of what we know now and where we can expect hopefully to see more guidance and rules as we get closer to the actual dates where the law is going to have an impact. Moving on to the next slide, please. So in terms of what employees will be eligible for paid family leave and what employers will be covered, it's pretty broad. The threshold's pretty low in terms of employee eligibility and employer coverage. The law defines an employee as an individual performing labor or services for the benefit of another. So it's pretty broad. They do provide a threshold of earnings of at least $2,500 in wages, which would be subject to the premiums under the law. And this would be during the employee's base period or alternative base period. Which means the base period is either the first 4 of the last 5 completed calendar quarters just immediately preceding the first day of the benefit year, or the alternative base period is the last 4 completed calendar quarters immediately preceding the benefit year. So that's the time period of eligibility that's looked at. And then this also includes people who are self-employed and elect coverage. And then in order to be eligible, the employee also has to submit an application for benefits and then follow what we predict is going to be some forthcoming administrative requirements to be eligible. So we'll look out for guidance on those aspects as well. In terms of a covered employer, this is going to be any person engaged in commerce or an industry or activity affecting commerce that employs at least one person for each working day during each of 20 or more calendar work weeks in the current or immediately preceding calendar year, or paid wages of $1,500 or more during any calendar quarter in the preceding calendar year. So as I said, it's pretty broad, and this covers a lot of employers, and it's not just limited. It's not just limited to looking at one employee in Colorado. We believe it to be employees anywhere, unless of course guidance is would say otherwise. Okay, moving on to the next slide, please. The amount of leave provided under the new Colorado law is 12 weeks in the aggregate for paid family and medical leave. So it's 12 weeks for any of the reasons, which we'll discuss in a minute here, but any of the reasons provided. And then it also provides 4 additional weeks with benefits for employees who have a serious health condition related to pregnancy complications or childbirth complications as well. Okay, moving on to the next slide, please. The reasons for leave, they look fairly typical to some of the other laws that we've talked about, as well as the Unpaid Federal Family Medical Leave Act. They include leave for birth, adoption, or placement through foster care for a new child during the first year after birth, adoption, or fostering. It provides leave for the employee's own serious health condition, and the serious health condition is defined in the law as an illness, injury, impairment, pregnancy, recovery from childbirth, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical care or facility, or continuing treatment by a healthcare provider. So they don't actually have to be in inpatient care or somewhere physically receiving treatment at the time that the leave is needed. It also provides coverage for employees who are caring for a family member with a serious health condition. And again, the family member definition is fairly typical. It includes children of all different types, including foster, stepchildren, children of a spouse or domestic partner, and this is regardless of age, which I wanted to point out is pretty important. It includes all different types of parents, people who the employee is legally married to or a domestic partner. It covers grandparents, grandchildren, and siblings. And then also importantly, it includes any other individual with whom the covered employee has a significant personal bond or is like a family member. So, and that's regardless of biological or legal relationship. So it defines family member very broadly. It also includes leave for qualifying exigency and also a safe leave component as well. Okay, moving on to the next slide. Okay, so the calculation of the weekly benefits that are going to be paid under the Colorado law are a little bit confusing, but you have to start with the state average weekly wage, which will be released, at the time when these benefits actually come into play. But looking at the state average weekly wage, any portion of the employee's weekly wage that is less than 50% of the state's average weekly wage will be replaced at 90%. And then any portion of the employee's weekly wage that is more than 50% of the state's average weekly wage will be replaced at 50%. However, once that calculation is done, the maximum weekly benefit can never exceed 90% of the state's average weekly wage, which is after January 1st, 2025, or at any period prior to January 1st, 2025, it cannot exceed $1,100. And I think we'll get more, indication of what that's going to look like when we know what the state's average weekly wage is when the benefits are going to be payable, starting in 2024. Okay, moving on to the next slide. In terms of the funding mechanism, between January 1st of 2023 and December 31st of 2024, this is going to consist of 0.9% of wages per employee. And then in 2025 and beyond, the director is going to set a premium based on a percent of the employee's wages, which may be the same or different than what it was in those preceding years. And in terms of the employee contributions, employers who have 10 plus employees, the employees will contribute 50% of the premium required. And then employees who work for an employer with less than 10 employees will contribute 50%, but the employer, the small employer exception here only requires that the employer remit 50% of that total premium. Okay, let's see, moving on to the next slide. There hasn't been a whole lot released on specific reporting and remitting requirements. At this point, we just know that on January 1st of 2023, that's when the premium payments are required to start being made into a fund to establish the benefit. So we expect there's going to be a lot more guidance issued on this topic. Okay, moving on to the notice and posting. There is both a notice and posting requirement. The model notice has not yet been released, but we expect it will be. And then employers are going to be required to provide this notice upon hire and anytime the employee notifies them that they need leave under this law. And then the model notice can also be used for purposes of the posting requirement. Okay, moving on to the next slide here. The leave under the Colorado law is job protected, and reinstatement is required if the employee was employed for 180 days prior to the leave. If they were not, then it does not provide the same job protection. But any employees, regardless of how long they were employed, they are not entitled to accrual of any seniority or employment benefits during their period of leave. And then they're not entitled to any greater rights to reinstatement than they would have been had they not been taking the leave. And similar to a lot of the other laws, this one also includes prohibitions, of course, on retaliation, discrimination, and interference with employees' right to take paid family and medical leave. Okay. And the last thing we'll cover on the Colorado law are private plans. Again, this is an area where we foresee some additional guidance probably being released, but there are employers do have the option to have a private plan. They have to apply for the division for approval. The requirements, as we know today, for a private plan to be approved, it must have the same reasons for use, must include the same benefits, including the amount of time off and the amount of payment received. It must allow intermittent leave in 1 hour increments. It cannot impose any additional conditions or restrictions on using paid family and medical leave, and there can't be any greater cost to the employees than is provided under the law. And then other aspects to look out for if you decide to do a private plan that is a self-insurance plan, there must be a bond furnished to the state. Private plans must be provided to all eligible employees throughout their employment. And if the plan is in the form of a third party that provides insurance, the forms must be approved by the state. Okay. So that covers some of the basics for the Colorado law. So now moving on to the Oregon law. We'll look at the important dates for the Oregon law, which this law was enacted in 2019, and similar to the expanded lead time, the payroll contributions don't actually begin until next year on January 1st of 2022, which is also coincides with the written notice requirement to employees. And then the benefits don't actually begin until January 1st of 2023. And similar to the Colorado law, although there's been some FAQs issued for the Oregon law, we do expect rules to be issued before September 1st of this year, at which point we definitely will have some additional information and hopefully some clarity behind some of the specifics of this law as well. Moving on to the next slide, please. The employee eligibility and coverage under this law is similarly broad. The covered individuals include any eligible employees, and this includes, the definition of employee as an individual performing services for an employer for remuneration, and it also includes a home care worker. So it's very broad. The definition of employee does not include an independent contractor, specifically exempts them from coverage here. But to be an eligible employee, you must have earned at least $1,000 in wages during the base year, or if not earning at least $1,000 in wages in the base year, the employee has to have earned them in the alternative base year, and they have to apply for the benefit. And again, this similar to how we talked about in Colorado, the definition of base year means the first 4 of the last 5 completed calendar quarters preceding the benefit year. It is also important to note that a covered individual does not typically include employees of tribal governments or the federal government. However, tribal governments may actually opt in which case those employees would be covered, and it does cover self-employed individuals as well. Okay, so moving on to the next slide, please. Employer eligibility and coverage. So covered employers include any person that employs 1 or more employees working anywhere in the state. So it's a very low threshold here as well. And employers, similarly, again, they do not include federal government or tribal government. And there is a small employer exception for employers who have fewer than 25 employees. They're not actually required to pay the 40% employer contribution that's required, which we'll talk about in a couple minutes here. But if the employer it is a small employer and they do elect to pay the 40% contribution, they are eligible to receive various assistance grants, which is, financial benefits that they can apply for. The grants cover up to $3,000 towards the cost of hiring temporary workers to replace the employees on leave, and up to $1,000 to reimburse additional wage-related costs while the employee is on leave. So there are benefits for small employers that do voluntarily opt to pay that 40% contribution. Okay, moving on to the next slide. Okay, the Oregon leave law provides 12 weeks for family leave, medical leave, or safe leave, a total of 16 weeks of the paid family leave plus unpaid Oregon family leave. So this is broken down as 12 weeks of the paid leave, plus then they're only entitled to an additional unpaid 4 weeks of Oregon family leave. And then they're also eligible for 2 weeks of benefits for limitations related to pregnancy, childbirth, or a related medical condition, and this includes lactation if they need time off for that. But it's important to note the total amount of time taken cannot exceed 18 weeks under the Oregon law. Okay, moving on to the next slide, please. Okay, so similar to the way the the Colorado law calculates the average weekly benefit, the average weekly benefit under the Oregon law is the employee's average weekly wage. If the employee's average weekly wage is 65% or less than the state's average weekly wage, then their wages are replaced at 100%. However, if the employee's average weekly wage is more than 65% of the state's average weekly wage, then there is a bit more of a calculation that goes into it. They get 65% of the state's average weekly wage plus 50% replaced of anything that's over 65% of the state's average weekly wage. And they also do set a maximum weekly benefit under the Oregon law as well, which is 120% of the state average weekly wage. And then the minimum is actually they actually do set a minimum, which is different from the Colorado law, which is 5% of the state's average weekly wage. So a little bit of math goes into calculating the weekly wage. Okay, moving on to the next slide. The covered reasons for use are very similar to some of the other laws that we've seen. It includes medical leave for the employee's own serious health condition, which is similarly defined as a lot of these other laws, so I won't read that. And I will note it includes any period of disability due to pregnancy as well, and also prenatal care, just to clarify. And then it also includes family leave, which is to care for a family member with a serious health condition, and to care for and bond with a child during their first year after birth, adoption, or being placed for foster. Family leave under this law, though, does not include bereavement leave like it does under the Oregon Family Leave Act, the unpaid leave entitlement. It does not include military leave. And it does not include leave to care for a child of the employee who is suffering from an illness, injury, or condition that is not a serious health condition as defined by the law. It also includes safe leave as well, and I know I'm getting close to my time here, so I won't read out all aspects of the safe leave, but it looks very similar to some of the paid sick leave laws that we're used to. Okay, moving on to the next slide. The funding mechanism here, employee and employer contributions start on January 1st of 2022. The total premium has not yet been set, but it is going to be a percentage of the total rate determined by the director of the employment department, and the total rate will not exceed 1% of employee wages up to a maximum of $132,900 in wages, and this will be adjusted annually. In terms of employer contributions, employers will be required to pay 40% of the total rate determined by the director and deduct 60% of the total rate from the employee. An employer may elect to pay the required employee contributions in whole or in part, but they're not required to, of course. Okay, moving on to the next slide, please. In terms of the reporting and remitting requirements, again, there's not a whole lot of guidance on this yet. We do anticipate there'll be quarterly reports. Those are due quarterly on the last day of the month following the completed calendar quarter. And the form of the report, however, is to be determined, but we expect to get some guidance on that in the coming months. Okay, moving on to the next slide. There is a notice requirement. Employers must provide written notice of each employee regarding the various duties and rights under the law, but there is no, at least to date, no poster requirement that we are aware of. Okay, moving on to the next slide. The Oregon paid family medical leave is job protected, but only if the employee was employed for 90 days before taking leave, except for employers with fewer than 25 employees. There is an exception there if the position held by the employee when the employee's leave commenced no longer exists. The small employer may, at the employer's discretion, based on business necessity, fill that position, but then reinstate the employee to a different position with similar job duties, benefits, and pay. And then finally, bringing us to the end, private plans are also permitted under the Oregon law, but must be approved by the director with an application, which there's a fee of $250 for, and we expect a form to be released, but that has not been released yet. And in terms of private plans, similar to the other laws as well, these must be available to employees All employees that meet the eligibility requirements, the benefits must be equivalent or greater than those required under the law, and it must be available to all employees who have been employed for 30 days. Okay, so that brings me to the end of the Oregon law, and I'm going to turn it over to Chelsea to talk about the California laws.
Thanks, Meg. Hopefully all of you can hear me. As we know, California really loves being the center of attention. So I think we had to add some new things to our PFL just so we could keep up with all these other new kids coming to the party. But before we talk about those very few changes, I did want to give a little bit of a refresh on California paid family leave. We've obviously been living with it for quite some time, but as a reminder of what it is a partial wage replacement program, and it is provided to California employees who are suffering a wage loss because they are taking time off for the various reasons, like providing care for an ill child, parent-in-law. You may recall several years ago, they added grandparent, grandchild, sibling to this list. And you can also use it for baby bonding, of course, and the amount of benefit tends to be about 60 to 70% of wages, but of course up to a cap, depending on what the person's income is. So someone who's a very high wage earner isn't going to actually get 60 to 70% of their wages. Employees in California do have the ability to coordinate this benefit with their own vacation, sick, PTO, up to 100% of their salary. So there is that ability to fill in the gap of what is missing after the state of California provides you your benefit. But very clearly what it is not a leave entitlement. It does not provide an employee the right to take time off or to extend the amount of time off they are taking, under the protections of SIFRA or FEMLA. And so it's a very common misconception in California, especially among employees, because we called it paid family leave, that employees assume that it gives them the ability to take time off. It actually does not. Nor does it extend time or give employees the ability to have their benefits guaranteed while they're taking it. So that I think provides a good refresh. And on the next slide, we can talk about something you may have missed because we were all a tiny bit busy with a global pandemic in 2020. The fact that there has been updates that happened within the last 7-8 months. There was a law that was passed back in 2019 saying that as of July 1st, 2020, the benefit period of time was going to increase from 6 weeks. It had been 6 weeks for many, many years, up to 8 weeks. And the goal of this bill was actually to try to keep that going, much like with minimum wage, it's on a sliding scale and increases every year. The idea with paid family leave was to create this task force that was going to create a proposal that would eventually come up with a plan that would, at some point, someday get us to 6 months, also raise the amount to 90% of wages, as well as create job protections for people taking paid family leave. That has not happened yet, so don't panic. We're not quite there. But this was something that was part of the bill that went into effect on July 1st, 2020, that there needs to be this task force and all the other stuff needs to happen. It just hasn't happened yet. Like I said, we've been a little busy. So along with paid family leave on the very next slide, I do want to talk just for a minute about San Francisco paid parental leave, because it was the first jurisdiction in the country to come up with a plan to fully compensate employees who were taking time off for bonding. And so essentially what it does, it takes the California paid family leave benefit. It requires that employers pay the difference between what the employee receives from the state and that maximum cap. And so it does kind of fill in the gap to a certain degree. And because PFL did change from 6 to 8 weeks in the middle of 2020, San Francisco paid parental leave did exactly the same thing. The original period of benefit under SFPPLO was 6 weeks. And as of July of last year, it moved from 6 weeks to 8 weeks. And so again, not a job protected leave. It is just a wage replacement. And it does provide some very unique aspects, though. If someone, for example, is on a paid parental leave under the San Francisco ordinance and is let go, like I said, no job protection, but the employer would have to keep paying the benefits through the end of that benefit period. So it's a little bit different than how PFL is actually administered. And you'll see on the bottom of this slide the eligibility requirements that come with SFPPLO if the employee has been with the organization for at least 180 days, if they work at least 8 hours per week in San Francisco. So clearly this employee could kind of work all over the Bay Area, but if they average that 8 hours in San Francisco, they are going to be covered by this law. as well as if it's 40% of their weekly hours. So it's sort of a hybrid how that works, depending on the number of hours the employee works and the percentage of those hours. They do, if the employer wants to mandate it as part of their program, have to apply for and receive those PFL benefits, because remember, this is a supplement to that. Although there are many employers we know that choose not to do that because math is hard. So you can do other things. You can pay the amount, and that would suffice under PPLO as well. But the more common is to actually just pay that difference. It obviously applies to all parents, all types of parents. And it would apply to part-time or temporary employees in addition to those full-time employees, as long as they are otherwise eligible. And again, doesn't give them the right to take the time off, but if they are suffering that wage loss because they have been given the ability to take the time off, SFPPLO will allow them to receive a supplement from what the state is already providing them up to 100% of their salary or the cap, whichever comes first. And on our final California slide, I do want to talk about what did happen in 2021 as of January 1st. Now, keeping in mind, again, California didn't want to be left out, so they did something to stay relevant. We're all familiar with the concept of qualifying exigencies because qualifying exigencies have been part of FMLA for a very long time. And so essentially what California did is they added to its PFL coverage the ability for an employee to receive benefits when they're taking time off because of a qualifying exigency. So when their spouse or their domestic partner or child or parent is in the armed forces and they are dealing with either being deployed or all of the things that go with being deployed, whether having to arrange for childcare or addressing any sort of legal needs or whatever it might be, the definitions of what a qualifying exigency under FMLA and under the PFL are now actually very similarly aligned. And one of the reasons for that is, and if you attended our California update webinar a couple of months ago on updating your handbook, you might have learned that CIFRA was updated to include qualifying exigency as well. And so in California, this is a new covered reason to take time off. And PFL and CIFRA have now kind of come together on this point in case an employee is taking time off for that reason. It is now covered under CIFRA. It is now also a qualifying reason to receive PFL benefits, which is a really interesting development, of course. It does have the definition for military member here. We've provided that for you. And even though it's not super common for an employer to have like a PFL policy within their materials, because again, it's a state program, it's not something that employers are required to actually draft a policy on. There is a pamphlet you're all probably aware that has to be provided at onboarding about California PFL, and that pamphlet has been updated for 2021. So I would recommend, if you're still using the pamphlet that you were using up until the end of 2020, or maybe you haven't even looked since they switched it from 6 to 8 weeks, now is a great time to go and click on the link for the EDD and take a look at what the new pamphlet looks like, because it does include qualifying exigency now. So anybody hired after January 1st, 2021 needs to get a copy of that new pamphlet. So on that note, there's California for you. I will pass over to Marlon, who's going to talk about New Jersey and New York.
Thank you, Chelsea. So before I get started on the New Jersey Family Leave Insurance Law, I just want to provide you with your CLE code, which is S as in Seyfarth, S as in Shaw, 8209. Again, S as in Seyfarth, S as in Shaw, 8209. One last time, SS as in Seyfarth, Shaw, 8209. And with that, I'll get started in talking about the New Jersey Paid Family Leave Law, which is known as the Family Leave Insurance Law, and I'll be referring to it as the FLI. So I wanted to start out about talking about some of the COVID-19 New Jersey developments. As you'll see on this slide, late March and early April were very busy for New Jersey. Governor Murphy signed into law 3 separate bills which impacted the various leave laws in New Jersey, including the FLI. The first bill that was passed was A3848, which went into effect immediately on March 20th. It provides that there is no retaliation and provides a right of reinstatement to employees who request or are absent because of a medical professional recommendation due to the employee having or likely having infectious disease. Two things to keep in mind here is that the right to reinstatement includes reinstating the employee in the position that the employee held when the leave started, with no reduction in seniority, pay, or benefits. Another thing to note is that the medical recommendation has to be written or electronically transmitted. Then just a few days later, after that bill was signed into law, Governor Murphy signed into law Bill S-2304, which was also effective immediately, and expanded leave benefits due to COVID-19 under several paid leave laws in New Jersey, including the FLI. Then in April, Governor Murphy signed S-2374 into law, which also went into effect immediately, but was retroactive to March 25th. This clarified and expanded certain aspects of these leave laws, including the FLI. Next slide, please. So in this slide, you'll see that we talk about 2019 amendments, and the reason we talk about these is because these were very significant amendments, and although some of them took effect in 2019, others were phased throughout the middle of 2020. What's important to keep in mind that all of these are currently in effect. And as you see, they were very significant. It doubled the amount of weeks that employees can take continuous FLI benefits from 6 weeks to 12 weeks in a 12-month period. If the leave is intermittent, that increased from 42 days to 56 days in a 12-month period. It also increased the monetary benefits that are available to employees from $881 per week to $903 per week in 2021. It expanded the reasons for use and covered family members, as we'll see in the next few slides. It also removed the 1-week waiting period, as well as updated the standard of interplay between employer-provided leave at full pay and the FLI. Next slide, please. So here we just wanted to provide a reminder of the employer coverage, which the law applies to private businesses and state government employers who are subject to New Jersey unemployment compensation law. So it's a very broad coverage standard. In terms of employee eligibility, you should be aware that there have been updates in 2021. In order for an employee to be eligible, they must have worked for 20 weeks, earning at least $220 weekly. This is up from $200 last year. Or they could have earned a combined total of $11,000 in a base year, which is up from $10,000 last year. Although the method of funding did not change and the program is still financed by worker payroll deductions and employers do not contribute to the program, the amounts that employees have to contribute changed. So for 2021, an employee has to contribute 0.28% of the first $138,200 that they earned during the calendar year, with a maximum yearly deduction for 2021 of $386.96. This is up significantly from the maximum deduction last year, which was approximately $215. Next slide, please. So in this slide, we first wanted to remind you of some of the reasons for use pre-COVID, as well as note the new addition of an additional reason to use. So prior to the COVID-19 amendments, employees could use the leave to care for a child during the 12 months after the child's birth, adoption, or foster care placement. They could also use it for a family member with a serious health condition in order to take care of them, as well as activities covered under the New Jersey SAFE Act. The COVID-19 bills that were passed into law added this additional reason for use that you see takes up most of the slide. Although this was added in light of COVID, it's important to keep in mind that it applies much more broadly than COVID-19, and it applies to communicable diseases in general. So this reason for use, employees can use leave during a state of emergency that has been declared by either the governor, the commissioner of health, or another authorized public health authority. And it can be taken for an illness that's caused by an epidemic of the communicable disease. So it doesn't just have to be COVID. A known or suspected exposure to the communicable disease, or efforts to prevent the spread of the communicable disease. In order for the leave to be taken, it has to require in-home care or treatment of the employee's family member, and it has to be due to the issuance of a healthcare provider or the commissioner or other public health authority of a determination that the presence in the community of the employee's family member may jeopardize the health of others, and the recommendation, direction, or order that's provided, or the authority that the family member be isolated or quarantined is as a result of a suspected exposure to communicable disease. So the most important thing to keep in mind here again is that it's not limited to COVID, although that was the reason why it was enacted. Next slide, please. And then the final thing I want to point out in New Jersey is the covered family members. So as you'll see, the first 9 reasons are pretty common amongst paid family leave laws, but as part of the 2019 amendments, there were 2 additional family members that were added, and these expanded the scope greatly because, as you'll see, they're kind of catch-all family members, including any individual related by blood to the employee or any other individual that the employee shows to have a close association with that's the equivalent of a family relationship. So this greatly expanded who the employee can use leave for. And with that, I'll be moving on to talking about New York paid family leave. So New York paid family leave was implemented in January 1st, 2018. That's when it first went into effect. However, it was implemented in phases, with the last phase going into effect just this January. So on January 1st, the full law is implemented. The eligibility standard has not changed. So for full-time employees who work 20 or more hours a week, they can use leave after 26 consecutive weeks of employment, and for part-time employees after 175 working days. Next slide, please. So as part of the full implementation of the law, there's been updates in regards to the amount of leave, as well as the amount of benefits that employees get. So as of January 1st, employees started receiving benefits up to 67% of the employee's average weekly wage, which is up from 60% last year. This amount is not to exceed 67% of the statewide average weekly wage of $1,450.17. In terms of amounts of leave, again, there was an update there. Now employees are eligible to take up to 12 weeks of leave, which is up from 10 weeks of leave in 2020. Funding has also been updated, and employees, it is still funded through employee payroll deduction, so the method did not change, but the amount of contribution is now just over 0.5% of the employee's gross wages each period, with a maximum contribution cap of $385.34. Next slide, please. So before we get into some of the new reasons for leave, we just wanted to remind you of the pre-COVID-19 reasons for leave, which are pretty typical. They include the care of a covered family member when that family member has a serious health condition, leave for bonding with a child, as well as the qualified exigency under the Federal Family Medical Leave Act. Next slide, please. And again, as a reminder, family members, they're pretty typical: child, spouse, domestic partner, parent, grandchild, or grandparent. Unlike New Jersey, there are no catch-all family members under the New York paid family leave law. Next slide, please. So now to the updates. So on March 18, 2020, Governor Cuomo signed into law in New York COVID-19 paid sick leave law. And the reason we're talking about it with paid family leave is because it also impacted the paid family leave, in addition to providing employees with additional sick leave for COVID-19 reasons. As you'll see on the slide, the amount of leave varies based on the size of the employer. So for employers with 10 or fewer employees and a net income of 1 million or less as of last January, employees are entitled to unpaid sick leave in connection with COVID. And we'll see the exact reasons on the next slide. But they're entitled to unpaid sick leave during that time. However, they are eligible for paid family leave, so they can apply for state paid family leave benefits and disability benefits during that time. For employers with 11 to 99 employees, or those with 10 or less employees and a net income of greater than 1 million as of last January, employees get 5 days of paid sick leave. However, for the remainder of the time that they need leave, they are eligible to apply for paid family leave and disability leave benefits. And finally, for employers with 100 or more employees as of last January, they're entitled to 14 days of paid sick leave, and it appears that there is no paid family leave benefits available to those employees, with the potential exception for care of a child subject to a covered order, which we'll see on the next page, on the next slide. So the first reason for use under this COVID law is that the employee themselves has to be subject to a mandatory or precautionary order of quarantine or isolation that's been issued either by the state of New York or another government entity that's authorized to issue such order due to COVID-19. So for this reason, employees can use leave, as we discussed in the last slide, and it does not appear to apply to employers of 100 or more employees. The second reason, however, is leave in connection with the care of minor dependent child of the employee who is subject to mandatory or precautionary order of quarantine or isolation issued by the state or an authorized government entity. For this reason, it's not quite clear if this applies to employers of all sizes or only to employers with 100 or fewer employees. The most likely reading of this is that it applies to all employers regardless of size. So the best thing to do is to permit employees to apply for paid family leave benefits and have the insurance carrier make the decision of whether they are eligible. And that is the end of what I'm covering for New York. And with that, I will pass it on to Josh.
Great, thank you, Marlon. Thanks again, everyone, for sticking with us through this. I know we covered a lot of ground. Just see on so we have a few more slides for you these next couple of minutes here. First, we're going to start with the paid family leave outlook for 2021 and on, and then we'll finish off with a couple of Seyfarth resources. One quick thing on New York. So I saw a couple of questions just come in a minute ago about how you determine employer size under the Emergency Leave Act that Marlon was just going over, that expanded portions of the state paid family leave law. The guidance isn't completely clear on whether you count only employees in the state of New York or employees across the entire U.S. So the more conservative reading would be to follow the latter in those situations where the law isn't clear. Also, as a heads up for New York, there's a chance, it looks like the state might be passing a vaccination paid leave mandate coming quite soon. It looks like it's made its way through the state legislature. So be on the lookout for a Seyfarth client alert on that in the next day or so. Okay, so paid family leave outlook for 2021 and on. We've already noted in Massachusetts, the benefits became available earlier this year on January 1st for all covered absences other than care of a family member with a serious health condition. That begins on July 1st of 2021, so just a couple of months from now. Connecticut, the benefits become available to eligible workers starting on January 1st of next year, 2022, followed each year successively by Oregon benefits coming online and then Colorado's benefits coming online, as Meg went over. So a lot of clients will ask us, what we are expecting to see in the state legislative session later this year in terms of new and additional paid family leave laws. What are the legislatures going to do? Are there going to be more paid family leave mandates getting passed? The locations listed here on the second half of this slide show what those most likely locations are going to be. Maryland and New Mexico in particular are two where we've been seeing a lot of activity, a lot of sort of Google alerts and hits for potential programs, being passed. Now, that doesn't mean the benefits would become available right away. It means that they would be implemented over time, similar to what we spoke about in Oregon, Colorado, and elsewhere. But in terms of a mandate getting passed and being added to that list of 11 that we started the program with, these are the locations to pay the most attention to. There are others as well, but these are the ones that are gaining the most attention. Next slide, please. Finally, if Seyfarth, if you want to reach out to Seyfarth about paid family leave needs, the patchwork of laws that we've covered today, we have really a great team, as you can tell from all of our speakers who specialize in this space. We also have some great resources available. We have a paid family leave premium survey, very comprehensive breakdown of about more than 30 substantive technical requirements of these various laws for every existing law that's out there. New laws come online, they'll be added to the mix as well. If you have any questions or want more information, there's a paidleave@seyfarth.com link there for you. We also have a mailing list that you can sign up for. It takes about a minute. The sign up link is there for you as well. If you sign up, you'll get all of our blog posts and client alerts on paid family leave. As we issue them, you'll be in the know. Next slide, please. So thank you, everyone, for submitting your questions. We did our best to respond to as many of them as possible throughout. Thanks again for submitting. And thank you, everyone, for attending, taking your time out of your busy schedules to join us for part 2 of our webinar series. Be on the lookout for more information on future parts in the next couple of weeks and months. And we look forward to seeing you there. Thanks again.
This concludes today's webinar. Thank you for attending.